Hello, thank you all for coming this morning. I will be discussing the ADA and interpreters. ADA stands for Americans with Disabilities Act. The abbreviation is ADA. The reason I chose the topic of interpreters is because many of you asked me to come and speak about interpreters and how they relate to the ADA. First, I want to give a brief overview of the ADA itself. So I'll give that short little description, and then I'll discuss how interpreters relate to each of the titles. There are 5 titles, but only the first 3 are directly related to interpreters. The last 2 are not so much. Title 1 is related to employment. That is any employment through a private company. The federal government uses a different document, so the post office system is a separate entity. The company must have 25 or more employees. That was back in July of '92, and this past summer, 25 has been reduced to 15. So if you have 15 employees, you must follow the ADA. If you have more than 15, then you do not need to adhere to the ADA. Oh no, I'm sorry. If you have more than 15 employees, then you must follow the ADA. If you have less than 15, then you do not have to, unless there is a state law that is more strict than the ADA. Title 2 is called Public Entities. That is referring to state and local governments. Again, we are not talking about the federal government, just state and local government. This can be various activities or programs. Title 3 is called Place of Public Accommodation. I describe public accommodations as a place where anybody can attend, or anybody can go to that activity. So this would be any private place like a restaurant or a theater, a hotel, anything like that would be under Title 3. Title 4 is the telecommunications, so like relay service. And Title 4 really beats all the others, because relay service has to be available 24 hours a day, 7 days a week, at all times. But they are allowed to be closed on Christmas. Do you believe me? No. They have to be open to the public 365 days a year. They have to provide equal access. The ADA requires equal access. So the relay service has to be equal in availability to the regular telephone system. Title 5 is called miscellaneous. That means anything that doesn't really fit into the other titles goes into Title 5. Federal law only covers the executive branch and the post office system. But what about the legislative branch? Like the post office, the Library of Congress. No, I'm sorry, not the post office. The printing service. That would also go into miscellaneous. So titles 4 and 5 are not related to interpreters, only titles 1, 2, and 3 are. So I will be discussing those 3. One thing that irks me with using interpreters when I'm talking about the ADA is that the interpreter will arrive to my talk and will not really know the technical jargon of the ADA. They can be a very skilled interpreter, but they'll start skewing my message. They won't use the right technical terminology. So it'll look like I'm speaking at a 5th grade level, but I'm more intelligent than that. So one of the specific terms that I use is effective, meaning, successful communication, all parties involved understand each other. But I use the specific term of effective. So throughout my speech, I'll use the sign that can also be voiced as successful. And really that means something different, effective and successful means different things. So the people in the audience who don't know much about in the interpreting system or the interpreting process, they'll think less of me. They'll think that I don't know what I'm talking about, when really it's the interpreter's responsibility and they're the ones skewing my message. So when interpreters really know the content of the ADA and the specific terms, they really match my signing style very well. So yeah, that situation happens often. So Titles 1, 2, and 3 are related to interpreters. Again, Title 1 is about employment. And for Title 1, the regulations and enforcement of the ADA is by the EOC. That stands for the Equal Employment Opportunity Commission. It's their responsibility to set up the rules, and if people have complaints through the ADA, they go to the EOC. But Title I has no definition of a qualified interpreter. There's no explanation for what that means. And the EOC has not written down a meaning of what it means either. The EOC in years past has been usually depending on the interpreter certification, but that is not written down anywhere. That's just what they have been traditionally using. Under the Title I, interpreters are considered a reasonable accommodation. That sort of means like an appropriate matching of the consumer's needs. And that's how I'll sign it, the correct matching. So, for employment, interpreters, this can mean various things. So a reasonable accommodation for, let's say, like a wheelchair-bound person could be when the desk is too low for them and they can't get their chair under the desk, or if the desk is too high and they can't see over. So the accommodation in that situation would be lowering the desk to a good height for them. And there are various examples of this, the same concept of lowering or raising the desk. And interpreters are considered one form of a reasonable accommodation. That's how interpreters relate to Title I. So I'd like to talk about who decides when interpreters should be used. The bosses of the companies have the final say of using an interpreter. Interpreters can be used in trainings, in meetings, evaluations, in the staff meeting, really anything, and it depends on the individual person. So if person A would need an interpreter in this situation, but person B wouldn't not need an interpreter in that same situation, you just have to follow their needs. It's a case-by-case basis. The manager has the ability to use the defense called undue hardship. It means that the burden is too great for them and they cannot provide an interpreter. Maybe they're a manager of a smaller company and their budget doesn't allow them, or maybe they have in the past and they can't afford it now. They just don't have enough in their expenses to afford that. They can use the defense of undue hardship. That would mean that if they provided the interpreter, the business would run the risk of going under. That is all related to Title I. I'm now going to move on to Titles 2 and 3. Titles 2 and 3 are often talked about together because the regulations and enforcements of Titles 2 and 3 are through the Department of Justice, the DOJ. So I'm going to talk about those two together now. Again, Title II is public entities, and Title III is public accommodation. And you'll notice that the first word is the same. They both have public. But public means different things in those two titles. For Title II, public means state and local governments, but for Title III, public actually means private companies. So it often happens that people will confuse the two of them of what they actually mean. So I already said regulations and enforcements are through the DOJ. The Department of Justice has a working definition of a qualified interpreter. So now there's a little bit of two different explanations between what they actually said and what people used in the past. In the past, we usually depended on, or the ADA depended on a certification system, but there was this discrepancy of, do we use the state certification system? Do we use the Registry of Interpreters for the Deaf, RID? And what about in rural areas who maybe have a totally different certification system, or they might not have any certification system? That happened to me before, actually. I was giving a talk in Iowa, and I'll be honest, I don't know much about the interpreting certification process or any of that, but it was a female conference, and so the conference committee wanted me to have a female certified interpreter, but Iowa City did not have a certified female interpreter. There was maybe one or two in the surrounding areas, but they were all busy, so they ended up flying in 2 female certified interpreters for my conference. And they were certified, skilled interpreters, so the committee followed my wishes, so I was happy about that, and I realized that these 2 interpreters were from Chicago. And I knew that the interpreters from Iowa City were all very skilled. They have deaf family members, but they were not certified. So the committee ended up needing to fly in some other interpreters. The DOJ thought about using the specific communities certification system because they would best know how to suit their consumers' needs. And that got a little bit confusing as the years went on, so they decided to just sit down and make a working definition of a qualified interpreter. Their definition says, and I'll be using the English legal terms for this, it says, a qualified interpreter is someone who is able to effectively, accurately, impartially, meaning staying neutral, both expressively and receptively, and can communicate using any necessary specialized vocabulary. That is the DOJ's definition of a qualified interpreter. So basically, a qualified interpreter should be able to facilitate communication so that all parties involved understand each other, so that me and the non-deaf person are on the same page. Accurately means that what I say and what the interpreter says are the same conceptually. Impartially means that the interpreter is not supporting one party or the other. There's no bias. They remain impartial throughout the communication process. There's no emotional ties to one party or the other. For example, whenever parents go to the doctor's office, they'll often bring in their children and say, "This is my family member, I want them to interpret for me." But they are not going to be impartial. Their children cannot disconnect from that situation. They're too deeply involved in what's going on. The definition says using any specialized vocabulary. So going back to the beginning of my talk, I told you about how if the interpreter is very fluent in their skills, but do not know about the technical terms of the ADA, that can affect the effectiveness of my talk. So for example, if a deaf student is in a medical school class, and the interpreter is a very skilled interpreter, very qualified, but they don't know very many scientific or medical terms, can they really interpret effectively? I'm thinking maybe not. So it's important to know the specialized vocabulary. Under Titles 2 and 3, interpreters are considered auxiliary aids and services. In the past, interpreters were referred to as reasonable accommodations back in Title 1. Auxiliary aids and services are used to ensure effective communication. For Titles 2 and 3, for Title 2, the use of the deaf person is given primary consideration when deciding what communication style to use, but again, the manager or the boss of the company has the final decision. For Title II, interpreters can be used in court, fire departments, things like that. In Title III, they can be used for private schools, doctor's appointments, meetings with lawyers, plays. In Titles II and III, employers can use the defense of undue burden. Back in Title I, you'll remember it was called undue hardship, but in Titles II and III, it's undue burden, and it means the same thing. The only thing that's different is the second word, that's all. The concept is the same. It just means that their responsibility is too great that they can't provide an interpreter. So, that is how the ADA relates to interpreters. If any of you need more help or need more advice on how to use interpreters or how to better follow the laws of the ADA, please contact me and I will continue providing my services. Thank you.